Hi, this is Anthony Parent, and thanks for joining me today on IRSMedic. And today we have our special guest, John Richardson of Citizenship Solutions, and Keith Redman, a global advocate for the American abroad. You can find him at Facebook on American Expatriates 2.0. We're going to be talking about an issue today, sort of always troubles us. It always comes up again and again and again. And because here's the reason, there's not clear answers. There's not clear answers and there's speculation. The issue that I'm talking about is what happens if you no longer consider yourself a U.S. person. And let's say years ago, you gave up your citizenship, but you never got something known as a certificate of loss of nationality. You never did anything. You haven't filed taxes in years. Maybe 80 years, maybe in the 1980s, you gave up your citizenship. And now your fear is this. Oh man, I'm reading something online and someone says, because I don't have a CLN, that means I am still subject to U.S. taxation. That means I better do something really quick about my years of noncompliance, or otherwise I'm going to end up with a bunch of civil penalties and potentially jail. So you can see why people are concerned about that. So this is something that John Richardson is a bit of an expert on, and I would just say probably the biggest expert I've ever encountered on this, because he understands so many of the different nuances, and he understands how people are misapplying certain terms of art. So John, thank you so much for joining us today. So what is going on here? Why do people think, why do people assume that if you do not have a formal certificate loss of nationality, that means you are still a U.S. person for tax purposes?
All right. Thanks, Anthony. Well, I don't think they assume it. I think that they are being specifically told that. Through a series of online articles, seminars, et cetera, et cetera. And interestingly, as of late, I don't know why, but I have gotten a number of inquiries, specifically on that issue. And to sort of synthesize the clusters of words in the question, it's sort of, is it true that the fact that although I relinquished U.S. citizenship for nationality purposes, the fact that I don't have a certificate of loss of nationality, a CLN, means that I'm still somehow a U.S. citizen for tax purposes? And, as you alluded to in your opening remarks, Anthony, the answer is it depends. And I'll try to explain that a bit, but let me just say, lest anybody get lost in the technicalities of this, that my message to you is that if somebody tells you that the absence of a CLN guarantees that you're a U.S. citizen for tax purposes, I would perhaps get a second opinion on that and explore that a little bit more fully, because it is not always true. It may be true. It may not be true. Now, are you ready, Anthony, for me to sort of take you through a legislative tour of the changes in the rules over the years? Or have you had enough already?
Well, I mean, and this is what people have to understand. Bear with us. It gets a little crazy as you have to follow things, follow the different.
There's some complexity to it.
A little bit. And here's the other problem that you have, and I think this is the fundamental understanding everybody needs to have. There's no real settled law on this. The IRS is silent, and there's not a lot of litigation. There's nothing, and so what you end up having is a bunch of tax professionals taking a big empty canvas, basically, and saying, what does this mean? And well, we could apply the law and make it mean various ways that are reasonable interpretations, especially in light of the fact of when you're an attorney, you see the IRS take very unreasonable positions. So when you're asking me, what does this mean? I'm like, well, it could mean something that's reasonable, or it could mean something that's unreasonable. We have to sort of figure out which is the most likely path. But I would say this, sort of lost in the discussion of all of this is, hey, which way is the IRS going to go, this way or that way? Well, just think about this. They haven't gone either way, have they? You would think, what, if the IRS was adamant about this, they would say, you know what, we're going to come out with those regulations. We could see all these people are really confused about what this means or not, but they haven't. And as I've mentioned before, my firm, we have yet to encounter an inquiry. Yet, I mean, thousands and thousands of Americans and U.S. persons call our firm all the time. They visit our website. They go to YouTube all the time. We have yet to encounter one inquiry from one U.S. person who is being subject to an exit tax audit. So it's something where we see the fear of this seems to be far, far greater than what the reality is. Now, the problem is, the IRS could really help us out there, right? Treasury could really help us out and say, oh, that's kind of why we come up with regulations. So practitioners are on their own trying to figure out what the best is. And then you have practitioners who are just sort of like, well, look, we're just going to take a position that is the most aggressive for the IRS. And that's what we're going to tell people to do. And maybe, and here's the thing, maybe the IRS actually doesn't want that, because we encounter this. The IRS doesn't want people to do these sometimes these massive disclosures we've seen. John, you and I have talked about that. People will say, oh, you have to do the full offshore voluntary disclosure program. But they really don't. There was IRS, and the IRS didn't want them to. And the IRS actually told us, why did this person do this? And I'll say, well, their previous attorney told them to file an offshore voluntary disclosure. And the IRS agent say, this is a waste of time. Why do they do this? I'm like, sorry, I can't undo it. So that is, I think, where we want to start off. And maybe that will help people understand sort of why it's so important to follow the legislative history, so that we can sort of keep track of what's what.
And
John,
if I may just add one,
ahead,
if I may just add one point, and then I'll let John speak, is how does this play in? You spoke about the IRS quite a bit, Anthony, because I know it's in regards to tax purposes. But where does the U.S. State Department play in this, vis-a-vis, is someone truly a U.S. person or not? If they had taken an act of relinquishment back in the 70s or 80s, does the State Department come into play, or is it just the IRS? That's a question. I don't know.
That's a great question.
Because I know with one person with whom we all know, he, when he did an act of relinquishment, so he thought, and the State Department has said, no, you're still in America. So there's a big question mark.
There's even that, right? Yeah, even right.
Yeah.
Great
So
point.
I guess it's up to John to.
All right, John, you ready? You're ready to start.
Well, thanks for all that information to preface it with. So, but actually, it's good to have the two of you on, because on a more macro level, Anthony talked a little bit about the tax issues. And interestingly, Keith talked a little bit about the nationality issues. And one of the problems here is that, when we deal with tax issues, as we all know, we're dealing with Treasury, IRS, and the Internal Revenue Code. When we're dealing with nationality issues, we're dealing with the State Department and the Immigration and Nationality Act. Now, what I think in trying to bring this stuff together in some kind of reasonable way, I'd like to begin with a statement, and then I will explain my statement. Okay, so here is my thinking on this. I think this is indisputably true. Okay. Prior to June 3rd, 2004, U.S. citizenship for tax purposes was completely a function of U.S. citizenship for nationality purposes. Let me repeat that. Prior to June 3rd, 2004, U.S. citizenship for tax purposes was completely a function of U.S. citizenship for nationality purposes. In other words, if you were not a U.S. citizen for nationality purposes, you clearly were not a U.S. citizen for tax purposes. Effective June 3rd, 2004, the government of Congress, in recognition of the fact that clearly U.S. citizenship is the greatest, the bestest citizenship in the whole wide world, thought, what would be a better gift to the American people than to give them yet another form of U.S. citizenship? So Congress made it so, and they created the tax citizen. So effective June 3rd, 2004, relinquishing U.S. citizenship for nationality purpose was simply not good enough. You also had to relinquish it for tax purposes, and that has involved different things. But generally, it requires notice, and the CLN, applying for the CLN, would establish that notice requirement. Okay. Now, let's go backwards a little bit and talk about the whole issue of whether, from a nationality point of view, prior to June 3rd, 2004, one would have relinquished U.S. citizenship or not. And I can only speak to this in a general way. If anybody's still listening to this podcast, I assume that you think it might apply to you in some way, shape, or form. Let me just say that I suggest that you get, decent counseling based on your facts and not just listen to this. But in a general sense, relinquishment of U.S. citizenship is governed by Section 349A of the Immigration and Nationality Act. And yes, not only does Section 349A matter in this discussion, but it is usually determinative of the issue. Now, what Section 349A does is establishes conduct which, if undertaken, voluntarily with a specific intention of relinquishing U.S. citizenship will result in relinquishment of U.S. citizenship. Now, let's take a very simple example. One that would apply, I think, to a lot of people would be an American moves outside the United States, voluntarily becomes a citizen of another country with the intention of relinquishing U.S. citizenship at that time. Let's say that's done in the 70s or something. Well, under U.S. nationality law, clearly, the person is relinquished U.S. citizenship. Some people say, well, what about the fact the person doesn't have a CON? Totally, absolutely irrelevant. Why? Because a reading of the statute makes it very clear that the relinquishment of U.S. citizenship is in no way, shape, or form dependent on having a certificate of loss of nationality. In fact, most of the people who relinquished during that time period don't even know what the thing is. So, that gives you, I can go a little further. I think I don't want to. I think I've said just about enough so that people can understand the basic framework. I've given the structure. In no way, shape, or form have I, tried to fill in the details here. But my message to you would be this, that if you believe there are grounds for your not being a U.S. citizen, and by the way, obviously, if after, having become a dual citizen, for example, you hold yourself out as a dual citizen, have a U.S. passport, et cetera, then clearly you're not going to be entitled to a certificate of loss of nationality because, they're going to use that as evidence against you that you didn't intend to relinquish your U.S. citizenship when you performed the act. But in a general sense, if you were one of the millions of people who left the United States, became a citizen of another country, did so believing that you were relinquishing your U.S. citizenship, have lived your life in that way from that point on, have never held yourself out to be a U.S. citizen, if you were in that position, and this is prior to 2004, and if you're now being told, Section 349A doesn't matter, that's just immigration stuff, that is, I believe, absolutely wrong, unless one can successfully argue the position that the current U.S. tax law, Section 877A of the Internal Revenue Code, was specifically designed to apply retroactively, specifically designed to capture every person who's ever left the United States and become a citizen of another country. Then go ahead, file the taxes and do all that kind of good stuff. But there's not 100% agreement on this. I have explained to you why I and a number of other lawyers, CPAs, etc., agree with me that those who relinquish U.S. citizenship prior to June 3rd, 2004 have a strong basis for taking the position that they are not U.S. citizens and therefore are not caught up in this whole brouhaha. Oh my God! Was that coherent?
Yeah, exactly. No. Here's my first question: has there ever been one instance that you know of where someone who relinquished between 2004 has later been determined to say, actually, you know what, you're a U.S. person. Sorry, so here's a bunch of taxes. Have you ever heard of that happening?
Not a person who had clearly relinquished. No. In other words, I have never heard of a case where somebody on the one hand met the requirements prior to 2004 to have relinquished U.S. citizenship under the immigration laws, who has somehow been hunted down and said, hey, you're a U.S. citizen. I have, on the other hand, seen, and this is regrettable, and, as somebody who tries to, behave professionally, I think it's a stain on the profession in that, but I have seen a number of people who were told that they were U.S. citizens, even though they didn't believe it, and for that reason entered the U.S. tax system and have been subjected to very significant taxes and penalties. For example, the transition tax, exit taxes, this sort of stuff. So, people have really got to be careful here.
So, and I think that's something that you and I have seen, is that in the effort to say, hey, I need to get out of the U.S. tax system, people have entered the system. You weren't in.
They have done that.
And sometimes people are looking for a certainty that might not exist. The cost of getting that certainty, you can get that certainty, do everything horrible and pay a lot of money, and I suppose you can get certainty. Will it do you any good is the question, for a risk that, and again, here is a risk that, you just said.
It's not going to do you any good, Anthony. Let me explain why, okay? Look, I think we can all agree that being a U.S. citizen or a former U.S. citizen outside the United States is a very, very bad way to live your life. I mean, I think there's no doubt about that. What I have seen
You
is that there
said
are
you said
people,
be a former U.S. citizen or be a U.S. citizen,
both,
John?
both. Okay, for the
Okay.
former, for the reasons that we're talking about, right?
Okay.
This kind of uncertainty, etc. There are many people who I think have thought they're being practical by saying, well, why don't I buy into the idea that I'm a U.S. citizen and I'll file taxes and maybe pay an
Yeah.
exit tax? Okay, that's probably, I mean, I think, sure, that's the cleanest way if you want the CLN and you want clear proof of everything settled up with the IRS. But, it solves one problem, but it's going to bring on another problem, which is that you will never be able to let go of the anger and the resentment
Oh God, no.
that you feel over it. So, I think it's one or the other. Again, my advice, I'm not, giving a sort of a general, this applies to everybody who doesn't, but for those who believe they relinquished U.S. citizenship prior to June 3rd, 2004, get some decent advice from somebody who understands how the nationality rules interact with the tax rules. Okay. And that is not, unfortunately, uh, U.S. law is so complicated that, we have silos of legal expertise. And, one of the biggest problems here is that the nationality lawyers don't understand the tax, and God knows the tax lawyers don't understand the nationality, sort of thing, right? But, again, I think, my message is there's a date here, June 3rd, 2004, where things change. Now, there are people who disagree with what I am saying. And obviously, I can't guarantee anything, in this world of, complex, badly drafted laws and lack of regulations. It's not the regulations, it's the lack of regulations that allow any accountant, lawyer, or advisor to put any spin on this that they want. But I find it impossible to believe that the intention of the current Section 877A rules, which came into force on June 16, 2008, were designed to apply retroactively to any U.S. citizen who left the United States at any point in time, going back to the beginning of time, would be subject to this. I mean, that's the kind of insanity that interpretation of the law implies.
I mean, you kind of have a ex post facto law a little bit there, sort of. That's kind of thing that a lot of people are thinking about there too. But I mean, this is something I just want to tell people who are listening to this. You probably been listening to the other podcasts, and this is a big issue to you. And I want to tell you that, my years of doing this is, I'm a tax guy. That's how I came into it. Well, there was a huge, gulf of lack of knowledge on a lot of these issues I didn't have. And John Richardson has helped us out so many times. And, my point is, if you are thinking about doing this and you have an advisor, please contact John. He really gets this. And this is the thing, that he is really, really on your side. He doesn't want to see you do anything more than you absolutely have to. I would say he's the foremost expert in the world on all of these issues. And I think a lot of people who know a lot would agree with me on that. So please, this is big stuff, big issues. This is no joke. And what he just said about the anger, do you know how angry you're going to be if you ruined your fortune for something that, you really didn't need to do that? You will have a hard time walking around this world, and you are going to look at everything different, and the cost of which can be quite ruinous. So really, John's a great value. Citizenshipsolutions.ca. Really reach out to my man here. He is really one of the best guys out there, one of the best attorneys, and he sees all the problems exactly as they really are, and he will weigh the balances. So, John, I hope you don't mind me doing a little bit of a sales pitch for you, but really, people are nuts.
Well, it's important. It's important for a lot of people who get caught up in this. Yeah.
Well, Anthony, I wasn't expecting that. I guess I do appreciate that. But as you said that, I was reminded once watching Larry Summers, the former Treasury Secretary, and I think the Clinton administration speak, and somebody introduced him. And I think what he said was, oh, that's the type of thing. If my father heard it, he'd be so proud. And if my mother heard it, she'd actually believe it. There are are a number of people in the world who get this type of stuff.
there are.
Okay,
Yeah.
for sure.
The thing too is if you do have a tax professional who's on the up and up, and they'll talk to John, it'll actually be good. It'll actually help them out, give people clarity. Like, okay, yep, good, all right, yep, we are on the right path. Yeah, that seems like we looked at everything. So just even adding John as an advisor to your expatriation, if you have these complicated issues, really, really money well spent. Just think about all of these things, moving pieces. And that's really the fear. Is like, how many times that I've encountered a case, someone comes in like, okay, yeah, this is what's going on with the IRS. And, I'm looking at this and I don't want to ask them the question why. I don't want to ask them, well, why did you do this? Because I know the answer. The answer is they didn't know. They listened to their tax professional. And now I'm going to tell someone like, well, why did you do this? Like, what do you mean? Why did I do this? Yeah, you shouldn't have. And that's a horrible thing to find out, that all of this money and headache and hassle was because somebody actually didn't understand the law, how it worked, and they were uncomfortable taking a tiny bit of risk to say, look, we have uncertainty here. I can't give you a certificate or anything, but I can tell you the most likely things of what is going to happen, and it's up to you to determine the risk. Too many often is that professionals want to eliminate all risk, and in doing so, created a larger risk. So that's why
I think on that point, you're absolutely right on that. If I can add something here, the thing that I find so difficult about this is precisely that, none of these conclusions one way or the other can, ever be justified 100%. So really, it seems to me that what we're looking for with people are defensible positions. I mean, in a world where you can never have certainty, the best you can probably get is a defensible position. And I think this is very, very important because, as you pointed out in your introductory remarks, Anthony, so many of the problems that have arisen from this stuff have arisen because people have entered these disclosure programs without a firm understanding or unprepared for what actually, was involved, and they were damaged because of their attempts at compliance. Or we look at the whole, 3528 brouhaha this past year. Who were the people who suffered? They were the people who were filing forms where, it was pretty clear that many of those things did not constitute trust at all. So what's happened is that I think this whole area has sort of morphed into, what can you do to, on the one hand, take a compliance position that is perhaps, I think, over compliance, because you don't want to risk being called out for not having filed a form or something when it's the very filing of the form that causes you the problem to begin with. Anyway, I don't want to divert too much from the the citizenship issue that we're talking about today.
So the other alternative, John,
let me just interrupt. I think what you guys are saying is that it is important to get a second opinion. Don't just take what your tax compliant, the CPA says to you. It is absolutely acceptable and needed to get a second opinion if you fall into this category. Wouldn't you agree?
Especially if you don't like the opinion. Yeah, especially if that opinion's going to cost you a lot of money. Hey, hold on before you do that. Maybe get and that's really, and I think that's really the point I want to drive home to people. John will absolutely, the way my firm works too, we're not here to have you do more than anything you need to. No more than what you absolutely need to, because we've seen the risk. And Keith, you've been here, you've seen the risk too, Keith. You're not a tax professional, but you've seen the risk too of people overfiling. Yeah. How the overfiling now gives you the basis to get these penalties because you really did more. The overkill. This idea like, well, I'll do the safer thing and I'll overkill. That's not safe. No, the safest thing is the safe. The safest thing is the safest thing, not the most aggressive thing.
The safest thing is to obviously comply, but comply doing as little as possible to meet the requirements and not more.
That's right, exactly.
Every single thing you file or do, you're just opening up another can of worms, right?
So now let's talk about the people who did absolutely. Now let's talk about the people who did make some sort of renunciation act. They did not get a certificate of loss of nationality after 2004. Let's say somebody who made the same relinquishing act, but it wasn't a CLN. Now, what about them? What if they did that earlier? Anything different for them? If someone did not get a CLN after 2004? Would you say that person is still a U.S. person for tax purposes?
Yeah. After June 3rd, 2004, they're either going to be – there were – okay. June 3rd, 2004 is the line in the sand. Okay.
Okay.
Before that, there wasn't the second tax citizenship problem. There was one set of rules from 2004 to June 16th, 2008, and then we have the current rules from 2008. But in both cases, there is a notice requirement. Okay. In other words, you can't just relinquish U.S. citizenship. So those people, yeah, they have issues. But even for those people, they need to be very, very careful what they do, how they do it. There are, particularly those who are potentially subject to exit taxes and that. I mean, there are ways of mitigating these problems. You're not going to be able to get the problem to go away if the Relinquishing Act is after 2004, but there's plenty of room for mitigation. I mean, it's a separate set of issues that you would work with.
All right.
Look, the worst thing you do, Anthony, is this. The worst thing you do after June is just, go renounce and then say, I'll clean up tax issues later. Okay, that is a disaster.
Don't do that. So get to that's, John, you and I agree on that big time. That's right. When you want to get all this stuff looked at, that is also something too, before you jump into say, oh my God, I'm in non-compliance, get an opinion on your compliance. Talk to us about your compliance. Say, actually, your compliance looks okay, because maybe you're okay.
Absolutely.
Instead of assuming. And that's something that, if you've listened to us, you might have heard that we don't have a great opinion of many people in the tax industry, that many of them just sort of will say, do too much for whatever reasons. So we do see a tax industry that will push people into programs that aren't appropriate because they don't understand sort of the fundamental things. Now, John, in 877A, this is kind of my question in there. I don't have the text of the statute in front of me, but I think you can answer this question on the top of your head. Does there anything to say this law shall apply retroactively? Does there anything?
No, there is not. No, there is not. But there's also not something that says it applies prospectively from June 16th, 2000.
Right, but the way the
argument is that the June 3rd variant specifically said that it did apply prospectively. But I don't think, honestly, Anthony, I mean, I don't want to get overly technical here, but I think that one can read 877A, very, very easily so that it would not apply to people who relinquished prior to 2004. Because if you look at the text, it talks about, being a citizen sort of thing, right? And I think the argument would be that you're not a citizen. It's really complicated. It is 877A, by the way. I once did a seminar on it. So I thought I'd print it out, and it turned out to be 15 pages of text. The whole thing is so complicated. But it's not, I don't believe it was intended to apply retroactively. If you fish around online, there's a great post, for example, and maybe I can, send this to you. Maybe you want to post it along with your general description of this. There are a large number of people who share my view on this. There are, I would say it's a minority who take the position that it is retroactive. There are no regulations on it at all. Treasury was actually asked 4 or 5 years ago to make a statement on this, and they've declined to do so, which is interesting. They've simply declined to do so. And, my view, which is, I think, just plain old-fashioned common sense, is this, that if you believe that you have grounds for having relinquished U.S. citizenship prior to June 3rd, 2004, I would think long and hard, okay, before, coming into compliance and all this stuff. By the way, also, before I forget, I have had this interesting scenario a couple of times where people were, they went to somebody and were told, well, they didn't think they were U.S. citizens. They hadn't lived like they were U.S. citizens. And they were told, though they were U.S. citizens, they actually entered the U.S. tax system, etc. And even in those circumstances, I can think of 2 cases where I was able to get them backdated relinquishments, back to the 70s. So, I mean, I'm not taking a position on whether, that would work for any particular person, but I have seen that work as well. Anyway, look, this is incredibly complex.
All right. Well, I do want to get to this because, first of all, we've been seeing a lot more interest in people, renouncing.
Renouncing. Oh yeah, yeah.
Yeah.
I mean,
There's
people are
been an
always
uptick.
interested. People are always interested, but people haven't been making those action steps of doing it. Now they are. Now we're
Yeah.
getting a lot of calls on exit tax, a lot of stuff. Whatever the reasons are, people are now moving on this. They've been considering it for many, many years, and now people are moving on it. Now, one thing that comes up a lot, because this is now really, really common. One of our videos on green cards is incredibly popular. So what about and this is the issue, a green card is just the card, documenting that you are a U.S. resident, alien. However, what happens if you live overseas with the green card? And then what happens after your green card expires? John, can you think of situations in there in which somebody may still be taxed as a U.S. person? And what should someone do if they haven't relinquished their green card exactly right, or they have questions about it?
Yeah. Very complicated. Okay, the bottom line is simply this. First of all, for listeners, the governing statute is section of Internal Revenue Code 7701B6. What it says very, very clearly is as long as you have the right to live in the United States as a permanent resident, that you're still considered to be a tax citizen. So in other words, a green card holder who leaves the United States, sets up shop overseas, who has not taken the steps to relinquish the green card, if you will, is still going to be subject to U.S. worldwide taxation. And this comes as a great shock to them. Now,
Even if the green card is expired, John?
The expiration of the green card has nothing to do with it whatsoever. Yeah. Here's the analogy. Okay. You're a U.S. citizen whether you have a passport or not. If you have a permanent resident visa, you have the right to live permanently in the United States, whether your green card is expired or not. In other words, it's more of a travel document, in that way. So the mistake is that people think that the expiration of the green card ends the status, and it doesn't from a tax point of view. Although interestingly, from a nationality point of view, I think a lot of these people would have trouble going back and just living in the United States. So the problem is that it's entirely possible, and I hope you're sitting down, under U.S. laws to not be a citizen, not have the right to live in the United States, but still be subject to worldwide taxation. Now that is subject to
right. I mean, I think that just bears repeating. You could be a non-U.S. person, not living in the U.S.
No, who doesn't even have a non-U.S. person doesn't have the legal right to live in the United States, but still
you can't even go there, right? You can't even go to the U.S. and you are still subject to worldwide taxation.
That's right.
That's by the U.S.
Right.
Yep.
Yeah. And I can tell you that, I do, well, basically I'm an expatriation lawyer. I do a lot of citizenship renunciation, but I can tell you that the green card stuff is usually far more complex because people who've been in the United States have 401ks and IRAs, all these types of things that are taxed very, very differently under the exit tax rules. Now, I suggest that we make that a separate podcast, Anthony, and perhaps.
I think you're right because that is. And actually, that is probably a really good idea to soon because, and from what I know,
and it's an important podcast to have.
Well, right, and because basically nearly every green card holder that I've encountered who leaves the country never thinks about anything else about it. Oh no, I'm fine. I don't have to worry. Oh, I wasn't here long enough. Maybe they looked at the exit tax like, okay, I was in the U.S. long enough. Oh yeah, I'm fine. I can just let it expire, let it go. Little do they know they may have this, and here's the problem that you have as that green card holder who was once in the U.S. See, there's a trail to you. There's these things that are in the U.S. that the IRS say, oh, what's this? Where does it go to? Oh, who does it follow? Now, and I think this is a separate podcast because look, if you're worried about the criminal charges, I think, we can, that's not really the issue. That's not really the issue.
You know what the issue is, Anthony? The issue is eventually getting that, the pension or the 401k, this stuff out. This is where I've seen this arise time after time. And, I would add also, that there are treaty implications here. All right. There is the possibility, although I don't know that I'd use it necessarily, of people leaving the United States, becoming a tax resident of another country, and using a tax treaty tie break to end U.S. tax citizenship, so to speak. Okay, that has some implications, which again we'll talk about in a different podcast. But it's an enormously complex situation, and I don't think it's just the people I work with. I've done enough. I mean, I think it's generally true that dealing with green card abandonment can be more complicated than dealing with citizenship renunciation.
That's right. Yeah. Yeah, I think that's going to be a separate podcast. So I think that's all we have for time today. And I just want to thank you again. And you know, like, what are the things that we say, guys? Right? There's no one size fits all. Don't assume the worst doomsday scenario. Overcompliance might not be the safest thing. And if you're doing this, maybe really give John Richardson a call. Give him an email.
And take your time. Take your time before you do anything.
Yeah, I actually, Keith, I think that is very, very important. You know, one of the things that doing this kind of work has subjected me to over the years is the avalanche of just panic and fear and this sort of stuff. And sometimes people have called me and said, listen, you know what, you're not even in a position to talk about this. You're so wired up. Why don't you go on a vacation for a week? Don't think about this. Give me a call when you get back. I guarantee you, if there's a problem, it'll still be there and you'll be able to listen. But there are huge emotional overtones to this. And when people are under extreme stress, they crave certainty more than anything else.
Oh, I know.
And
Very true.
So they're very, very susceptible to, solutions that will create, like give all your money to the IRS.
Yeah, right.
The other thing that I will throw out here that I've noticed over the years is, I've often wondered why is the case that some people are more impacted by this emotionally than others? And I've noticed that there's a tremendous correlation between this problem popping up on the radar and it coinciding with some other big issue, a health concern, perhaps a divorce, this sort of stuff. It magnifies these things tremendously. And, I'm not suggesting it should magnify it. I get that totally. But I think people should realize, that may be a reason why they're feeling so desperate at that particular moment. And I think also single people, there's nothing like having a non-U.S. spouse who says, what are you, crazy? You're out of your mind. This can't really be going on. Can we please have dinner now? Would you shut up? I don't want to hear about this anymore.
Absolutely.
That can be a great help, okay, as opposed to sitting there alone reading all the online horror stories, right? And then going to sleep and having a nightmare where you're dreaming you're a U.S. citizen. I mean, what could be worse than that?
Yeah. Well, all right, so I think
anyway.
Well, thank you so much, guys. Again, check out John at citizenshipsolutions.ca and join Keith at Facebook at American Expatriates 2.0. I do love what you say there. That this is not this is not a one size fits all. There's just so many moving pieces here. So again, this is Anthony Parent. Thank you so much for joining us, and please be sure to subscribe.